Superplus factors law everyone should know. The superplus factor in Sherman Act antitrust law. The problem of the invisible agreement. Section 1 of the Sherman Act, the foundational federal antitrust statute, now well over a century old, prohibits conspiracies that restrain trade. Uniquely, it is both a civil and a criminal law. Violators may face not only private lawsuits and substantial damages, but also federal prosecution, fines, and imprisonment. The law's target is clear. Competitors must not collude to fix prices, divide markets, or rig bids. But the law's challenge is equally clear. Genuine conspiracies are rarely documented. Executives who break the law do not typically leave a paper trail. The agreement, if there is one, lives in private conversations, in winks and nods, in the unspoken understanding that everyone in the room shares. How do courts and juries find a hidden conspiracy? The answer, developed over decades of case law, lies in a category of circumstantial evidence called plus factors. What are plus factors? Parallel conduct alone, competitors doing the same thing at the same time, is not illegal. In a competitive market, businesses often respond to the same economic pressures in the same way. If the cost of raw materials rises sharply, every manufacturer in an industry might raise prices around the same time. That is not conspiracy. That is the market working as it should. Plus factors are pieces of evidence that, when added to parallel conduct, tip the scales toward an inference of conspiracy. They are the circumstantial fingerprints that suggest the companies were not simply reacting to the same market forces independently, but were instead moving together, coordinated, synchronized, and aware of one another's intentions in advance. Common plus factors include evidence that the parallel behavior was against each firm's individual self-interest if acting alone, evidence of a motive to conspire, and evidence of opportunities to communicate. No single plus factor is automatically decisive. Courts look at the totality of the picture, the whole mosaic of conduct, context, and circumstance. But not all plus factors carry equal weight. Some are far more powerful than others, and one stands above the rest. The superplus factor, no plausible legitimate business rationale. The most powerful of all the plus factors, sometimes called a superplus factor by legal scholars and courts, is the absence of any plausible legitimate business rationale for the challenged conduct. In plain terms, when an industry's behavior makes no economic sense for any individual company acting alone, that irrationality becomes powerful evidence that the companies were not, in fact, acting alone. Consider what this means in practice. Businesses exist to make money. Rational companies do not voluntarily sacrifice profits, give up customers, shun new markets, or adopt policies that harm themselves, unless they have a good reason. When an entire industry behaves in a way that would be economically self-destructive for any single firm acting independently, the law asks a simple question. Why would they do that? If no satisfying competitive answer exists, if the behavior only makes sense as part of a coordinated scheme, then the absence of a legitimate rationale becomes nearly as powerful as a signed agreement. The conduct itself speaks. The silence where a business justification should be becomes an admission. Why it carries such weight. Other plus factors tend to be suggestive. They raise questions, invite inference, and narrow the range of innocent explanations. But they can usually be countered. A company accused of conspiracy can point to falling demand, rising costs, a new competitor, or a dozen other legitimate market forces to explain why its behavior happened to mirror its rival's behavior. The superplus factor is different because it closes off those exits. When a defendant cannot offer any coherent business reason for what the industry did, when the only explanation that fits the facts is coordination, the evidentiary force of that void is enormous. It transforms the case from one where a jury must choose between a conspiratorial and an innocent explanation, to one where only a conspiratorial explanation remains standing. This is, in essence, the logic of deduction applied to markets. When every innocent explanation has been eliminated, whatever remains, however hidden, however carefully concealed, must be the truth. The law does not require a confession. It requires only that the evidence, taken as a whole, leads to no other reasonable conclusion. A powerful tool in the pursuit of fair markets. Antitrust enforcement would be nearly impossible if courts demanded direct proof of every conspiracy. Sophisticated actors rarely provide it. The plus-factor framework, and the super-plus factor at its apex, gives the law the tools to reach conduct that harms consumers and distorts competition. Unfortunately, it seems that the too big to fail are also too big to be subject to the rule of law.